about 15 days and tell them you better find it or it'll be conversion. Breach
your trust, yeah. So, would I do it on a notice of interest or just a simple letter?
Of interest, yeah, that would be just a claim. Hey, you breached the trust, you lost my deposit, you commingled the funds, got your conversion.
Hey, Christian, it's JC. Good evening.
Hey, JC, how are you?
Good, thank you. I'm trying to dial in from Skype, and it's not letting me in, so I just want to make sure this is the right line. I'm going to try a few more times. I'll be hanging up here and trying back on Skype. So I'll see you in a bit.
Okay. Hear me okay? Somebody press *6. I think that's unmute. Let me know if you read me okay.
Yeah, we can hear you.
Me? Okay. Can I hear you? Okay, well, we'll get started.
Hello?
Start recording then. Yes, Pete. Can you hear me okay?
Yeah. Loud and clear. It just confused me, okay. With the *6 to unmute. That was all.
Yeah, was it *6? *6?
Yeah, you have to, it must take you automatically to mute, and then you have to, press *6 to unmute and mute again.
Press 5, that did everybody out, so that they'd have to unmute themselves to talk, which I guess is *6.
Yeah, it doesn't give you any indication of that. So I was talking away there and then wasn't getting much in the way of a response.
That's because you weren't being heard.
I know that. But I wanted to run one thing by you.
Go ahead.
Which was, remember, I think it was last week when I was reading out the 2006 book about agency, and the agent doesn't have any enforceable means by the beneficiary to act.
Right.
I was just I'm chasing that up in some of the old books, and it does seem to have some validity. But I'll get back to you with anything that I find on that.
What in particular were you looking for? I think you might find something that's...
Well, if the agent is given the trust property and then he's under no obligation to give it to the beneficiary, seems a bit pointless.
Yeah, that was when the trust res transferred. Therefore, the trust hadn't been formed, and therefore the agent really didn't have a trust to be obligated to any kind of duty as trustee.
It just doesn't say it that way, though. It says that, the trust is formed, but he's holding it, as maybe executor. Well, in the modern book,
as was transferred to some trustee, and then the agent of the trustee, it now has the trust property. He's not obligated to the beneficiary. Is that what you're saying?
Yes. Yeah. He's an outside party.
Okay, I wonder if maybe the agent might not be responsible to the beneficiary, but still the beneficiary would have rights up against the trustee, and he would have a claim against him for transferring trust property that was due to him. Yeah, I would agree that the trustee had possession and the ability to do anything he wants with that trust property, and if he gave it to somebody else for whatever reason, he's still liable to the beneficiary, but the agent wouldn't be.
Yeah, so it would take the beneficiary, should there be no appointment of a trustee, and that was where the grantor used an agent, then the beneficiary would have to appoint a trustee, and then he can then enforce the trust to the agent. But it wouldn't necessarily be the agent's job to look for a trustee for the beneficiary.
But prior to that, there was transfer of trust res property by the grantor to the trustee. But the trustee and the agent is not one and the same.
No.
Right?
Yeah.
They're two just separate parties.
Yep.
Okay, so then so the grantor would be, the beneficiary would be, have no claim against the agent, but he would have a claim against the trustee.
Which he could appoint.
The beneficiary could appoint, if he was a sole beneficiary, or if all the beneficiaries agreed.
Yeah.
So you mean he might want to appoint a new trustee? You mean?
Yeah, because just by the very character of the trust itself, it could be an aunt in New Zealand leaves something for someone who's off in Russia traveling around the world. So, she hasn't got any other relatives or anyone who she can trust, but she's got an agent who she can use for the benefit of the beneficiary for when he appoints a trustee, and then the agent then can, transfer the property. But someone couldn't just come in and say, well, I'm the trustee, and sort of take it from the agent. Do you know what I mean?
Well, I'm coming back to where something's not quite clear here, that there was a present transfer of trust property to the trustee. There would have to be for the trust to form. Then why would there be another need to appoint another trustee then? If there was a trustee already appointed.
Yeah.
Who would the trustee be then? If you say the aunt had another party that she was going to appoint as agent, but who did she get that was the trustee? Who was the trustee first?
True. Yeah, that clears that all up for me. Thanks.
There'd have to have present transfer of trust property to a trustee already. Whoever received trust property, that would have to be the trustee. So I'm thinking that trustee exists, but then for some reason he would say transfer it over, because he's got sole rights to do whatever he wants with the trust property. He could transfer it to another party, and that another party really didn't have any legal right to it, although he could sell the property or maybe donate it or something, but the trustee would still be liable to the beneficiary, and the beneficiary could still come at him with a claim as trustee, because the trust property should have been dispersed to the beneficiary instead of this other agent. So it can't be that the trust was created to be a violation of the grant, or that the trust was created for the beneficiary of this agent. No, it had to be for the beneficiaries instead of the agent, unless this agent had some kind of co-beneficiary status. So do you have that book where you're reading from?
Yeah.
You have it in front of you there?
Yep.
Can you read that part again?
Hey, Christian, it's JC. I got back on the main landline. I'm trying to connect through Skype still, but I've been on for about 6 minutes now, and I missed the, what is the purpose of this over the agent and trustee?
Well, that's kind of like what I was trying to, that's what I was trying to determine. So he's going to read it again, so. He was giving an example there that aunt was the beneficiary, and I forget exactly how he put it now.
Well, I'll do it from the diagram in the booth. but it's about powers of appointment and redistribution. That's the title of the chapter. Yeah, so you've got the nature of the powers.
Is that in the treatise?
No, it's not. It's in a modern book, The Law of Trusts and Equitable Obligations.
That one was 2009 edition, you said?
2006.
2006, okay. Go ahead and read it.
Powers of appointment are one of the equitable mechanisms which facilitates the management and allocation of property. The key feature of a power of appointment is that it is discretionary in character, unlike a fixed trust or a discretionary trust. The donee of a power is under no enforceable obligation to make any appointments of the fund at all. Even if the donee were never to make any appointments at all, he would not be in breach of duty owed either to the donor or to the potential objects of the power.
Yeah, I would agree with that because the agent wouldn't be the trustee, and he wouldn't owe a duty to the beneficiary then. So this is kind of like giving an example of the power of appointment of the trustee to appoint another agent.
It does look like it would be the trustee who would choose the agent, yeah?
So is this like the trustee transferring power to this new agent as trustee? Or is he just acting as an agent? Does it explain anything other than that?
Yeah. I mean, there's a full chapter on it with such titles. Yeah, Classification of powers of duties of the donees of a power, rights of the objects of powers, the validity of powers of appointment, which goes on to certainty of objects by comparing it with fixed trusts, the is or is not test, and then it goes into capriciousness. Even if a special power of appointment is sufficiently certain, it will be invalid if it is capricious in nature. Exercise of powers of appointment, defective exercise, contracts to exercise, excessive exercise, duties of the donee of a bare power of appointment. Yeah, so it's quite in depth. I'm going to look through it, chase it up, and then I'll relate it then to some of the old books, and then I'll get back to you with the outcome of that.
So my question is that agent acting as a co-trustee, or is he just acting solely as an agent for the trustee personally? Because I think if he would be a co-trustee as an agent, he would be liable to the beneficiary, I'd say. But if he is personally did this deal with the trustee, then personally he wouldn't be liable to the beneficiary as an agent.
Yes.
It would just be because it sounds like the trustee would transfer the property or something, which he didn't have a really in violation of the beneficiary's right. That's kind of the way I'm kind of taking it. He had the right to transfer the property as being trustee because he has total say-so over the property, but he owes a duty to the beneficiary to transfer and distribute the property to the beneficiary. He might not have done that. Maybe he gave it to some other agent or something to do something with personally for it. But that doesn't I don't think it forgives the trustee the liability in violation of the duty to the beneficiary. So the beneficiary, I think, would still have rights to come back against the trustee under equity, and maybe some kind of at-law remedies also against the agent. That's kind of the way I would see it, without really going through that chapter.
Sure. Yeah.
Does anybody else got anything on JC? Anything?
I do. Actually, I do. And I'm sad. I've tried about 20 times through Skype to get in, and it gives me a network error. So I'm sure somebody will record this call and I'll go through it. That's fine. So here's my my big question, and I got our group together before to just talk about some of these matters. There is a lot of people going through a private administrative process, administrative commercial claim, or whatever you want to call it, and they're doing that for taxes, they're doing mortgage issues, they're doing it for debt collectors, and the biggest hurdle that people have come across is how to take that administrative process going into the public and get a public judgment or something that will either create an estoppel or otherwise. So the matter is the following. When you create a private administrative judgment or administrative agreement between two parties or through tacit arbitration, you get the certificate of non-response by the notary for the entire process, because they'll never respond to you probably. And at the end of the day, you're holding what was formerly called a certificate of notary protest, but the evolution of that document has really just become acquiescence by or assent by or something to that effect. And you have that certified by the notary. That is effectively your title. And what is that the title to? Normally and I want to do the contradistinction between that and what happens when a bill collector sends you a present. When you get a presentment in the mail,
okay,
they're holding still the legal title to that. You're going to claim that equitable. You're going to move it back to them through the MTT Moving Titles platform, and you're going to merge the title through that claim, through that legal equitable compression. Well, that doesn't really happen when you start the process with your ACC, because you are creating the legal title with your energy, sending it to them. So I guess part of the question is, let's talk about the titles. What does that document, that certificate of non-response, represent in terms of a title? And then when you have that and you've run the ACC, how do you bring that into the public? Do you need to just claim it on UCC1 because you hold equitable and legal title to that? Or do you need to transfer that back to them? And if you do, why would you need to transfer it? Does that just represent a liability to them? So I just want to kind of brainstorm on that, because at the end of the day, what we want to do is we want to be able to take that thing, put that into the public realm, and open up a court case, because ideally I'd like to turn that into a trust res. So I think if everybody could take that certificate of non-response, turn it into a trust res, and then open a court case based on trust law, like per SNEP, then we're back in trust law, instead of having some kind of quasi breach of contract, which they will now never happened, didn't have notice, or for whatever reason, and then we're back into the contract issue, breach of contract. So I want to attack all of these ACCs from a trust standpoint, and that's where we are.
Okay, what did you call them again? ACCs?
Well, they're an administrative commercial claim. They used to be called international commercial claim. Some call it private administrative agreement. So let's just call it administrative process. Private administrative process.
All right. Right. So what was the first question you want to address? The certificate, the non-response?
Yeah, what does a certificate of non-response represent?
When we used to do those lien formations, the non-response was the breach of the agreement, but yet there was the notary certification that the other document was his hand and seal that created that. But, you know, it really doesn't have a value until you put a true bill in there. And that true bill would make it, you know, a value that you could create it under debtor creditor as a lien. But I think you make a good point there when you say, you know, we want to come under trust, and under trust, we don't have to have a value. So we really probably wouldn't have to put a true bill. Could. And then use it as a special deposit. So that certificate that was generated, the last step of the presentment. So we're just kind of like creating a lien under that three-step process, and then taking that and using that as the specific trust res and bringing that in. And I was thinking about that the other day, and it was talking, let's see, how was I thinking about that? When they come into court, back down to the censure, we've got to remember that in the public realm, you do not have to have a censure, and if you don't, you're operating as the fiction. So you don't have to have knowledge or understanding that what's going on, and how they determine whether or not somebody has knowledge or understanding is the... So now we're talking about it being a record, and the notary is creating the record. That's going to be something that they could see, because they're not going to be able to say, I brought this into court on the public side and start arguing this. They're in this agreement or this trust, and they're going to say, no, I never agreed to that. It wasn't my intent. But, you know, okay, who is speaking now? Is it the real man that is speaking on the behalf of the straw man attorney? Because the real man can't be heard in that court. And the only thing that they can hear from really the attorney say would be as a fiction. And as a fiction, they would have to have some kind of record. So they don't really have a record, otherwise they're speaking and they're saying, well, you know, I wasn't my intent to form a trust. But you're going to come in with a record and say, well, that doesn't make any difference, because you're changing your mind, because now you're saying that you didn't agree, wasn't your intent, but yet I've got a record here that says otherwise. And really, that's how they come at you. So it comes back down to the center again, that they're going to come at you. Maybe they're not realizing what they're doing, but really they're getting you to agree by a record that it was your intent, that you had knowledge and understanding when all along you didn't. But in the same thing, reverse it on them. They might not be understanding what they're doing, because really now they're speaking about it wasn't their intent, but yet you've got a record to prove that they did know and understand by a record, even though that they didn't have censure and really know and understand. Because now they're acting like the real man and testifying when they really can't, and they really shouldn't be heard in court. They probably aren't, but we're not enforcing that. Because I would keep coming back to my fact that I have a record, and I don't care what you're speaking in open court, because the action recorded as a deed is going to be recontracting over what you say. And really, there's no open testimony in court until we get to trial, so whatever you're saying is hearsay anyway. Because I need to swear you in, put you on a stand, and cross-examine you. So I think that their strength is they're coming at us because we really don't understand how this game is being played in court, but yet they're just as weak on the opposite end, because if we start coming at them, they're going to come back down to the same way that we would and say, they're going to argue, hey, I didn't agree with that. It was not our intent to form this trust. That doesn't really count. What really counts is, do you have the record? Because the record is going to prove that they knew and understand even when they didn't. Because in that public realm, it's the record that counts, and that doesn't represent censure. It just represents the way they're operating in that realm. So the dishonor, whether or not it has a value on it or not, under trust, makes no difference to me, because it's going to be the thing. And I'm going to use the thing because it's the offer for the trust that they're throwing at me to begin with, that I'm going to turn right back around and use it as the counter title, as it being an asset of whatever value you want to put on this, and we're really not talking about values, because under trust it doesn't make any difference about value. We don't have to have any money. It's just a thing. So the offer that you gave me, I'm going to back to you as the counter thing, and the two out. Because one's an asset offer, the other one's a debt tender, or it was a debt tendered offer and an asset tendered back, which is going to counter the amount and bring them to zero.
And that's where the idea of there's this bifurcation between the presentment and then, for example, just a private administrative process. On the one hand, you're getting a presentment from a bill collector, and then you're doing that whole process with that. Whether you initially A for V that, or whether you claim that, whether you run your ACC process 1, 2, 3 times to get your certificate of non-response, or if you just simply say, for example, they damage you in the public somehow. Say they levy a bank account, and you then start the administrative process and tell them, through these different points and your affidavit and your other points of fact, and that they failed to respond to, then you get the certificate of non-response, tacit acquiescence for those points that then become the record. So once you have that record, then, and by the way, I would imagine most people doing this process will probably end up with some type of a true bill. That's the whole core of why you're doing that. So you can put, or at least formally in debtor-creditor land, you could put some type of a number and create some type of lien or maritime lien or whatever the debtor-creditor latest technology is. So even, I would say, as of today, probably most people do have some type of some certain based on these infractions that have gone on. They've run the process. That number is some certain they can put on a UCC one if they want, but mostly they have the certificate of non-response, which again, as you say, it does not need any type of a number. So, because they didn't send you a presentment to begin with, how are you going to turn that into a trust res? And are you going to look at that certificate of non-response as your asset, because whether there's a number attached to it through a true bill or not, it's your asset, and they are in default on a claim that you made. So is that how you're looking at that?
Yeah, I would think if I was going to put a true bill in, because most everybody's doing these true bills under debtor-creditor, they're not putting a specific sum certain under lawful money, say, under pre-1933, where then you would have some kind of specific value. Because really, in a fiction realm, how can you have anything of any value if what you're measuring it with has no value to begin with? Everything would be valueless. We're talking about no value of anything at all, because we're not really talking about real specie money that's being pre-1933. Now I can come back in with my equitable asset if it was pre-33, where under Black's Law Revised Forthwith said that equitable assets are assets which are chargeable with the payment of debts or legacies in equity, and which do not fall under description of legal assets, and those portions of the property which by the ordinary rules of law are exempt from debts, but which the testator or the grantor has voluntarily charged as assets, for which being non-existent at law have been created in equity. And they are so called because they can be reached only by the aid and instrumentality of a court of equity, and because their distribution is governed by a different rule from that which governs the distribution of. So that's the whole thing. How is this created, under what realm, and which realm are you claiming? Because equitable assets is different, under a different law form than the legal assets, and how it's going to be distributed or classified, or because they say up here that under one side it's non-existent at law. My asset does not exist at law. but because they've been created in inequity. And it can only be reached by the aid and instrumentality of a court in equity, because their distribution is governed by a different rule from that which governs the distribution of legal assets.
Okay, so you create. I'm sorry. Go ahead.
It's really hard in our mind to keep straight. We're actually dealing with two realms. Not only pre and post 1933, but then also in court, a different kind of equity for the public and a different kind of equity, which is pre-equity, 33 equity in chambers. The equity of the public side of the court is nothing more than just the statutes and codes anyway. So, I don't mean to interrupt you. Go ahead there.
No, sorry. I'm actually connected to repeat, so it's a little bit fuzzy. I'm sorry, but at least I'm on, so I appreciate that. So essentially then we've created an equitable asset through the certificate of non-response, and that's where we're holding. We're holding title to this equitable asset, regardless of whether there's a debtor-creditor true bill attached to it and some certain dollars or euros or other fiat currency. Would that be fair to say that that title and a certificate of non-response is an equitable asset?
Yeah, if you make it, say, a specific sum certain of pre-1933 money.
Okay. If you didn't do that, but you put it in terms of a current fiat currency, and you have a true bill associated with that, and there's a lot of people out there right now who have mortgages, who have put these banks into that administrative position where they have no wiggle room. What would you do with that administrative claim that has the certificate of non-response attached to it?
How are they treating the original asset, the lien or the value of them? Is a debtor creditor, pre-19 or post-1933 asset, which would be
we can treat it however we want. We have the asset. Let's treat it however we're going to get the most bang for the buck. And to me, it's running like a snap, and we're going to open up if we're in a court case, we'll do a counterclaim. If we just want to be proactive, we'll open up a court case after we turn that into trust res, and do a breach of fiduciary and bad faith and conversion and all the rest.
That asset may have two faces. It may have a equitable side. It may have an asset side under the public side.
I was going to say.
So it may be simultaneously. It may be simultaneously both. I never really thought about that aspect, but it could be. Now that I'm thinking about it.
Can you hear me, Christian?
Yeah, Harold, go ahead.
Okay. When he defaults them out on the administrative process, that's being done under debtor-creditor.
Yeah, I would agree, yeah.
That's being done under debtor-creditor, so I agree that it may be converted, but initially it's debtor-creditor, and to use that in a court, like he said, for the most bang for the buck, I would basically stick with your initial suggestion, is just to get it registered properly so it can be seen in the public, and do a claim against them in the public realm that they had no standing or position to go forward, being that they haven't validated or they have not refuted the claim.
And what process, Harold, would you use forward in the public?
Well, you could, once it's properly registered, 2 signatures under seal, you can go into their court. Let's take, for instance, a foreclosure action. And say you're in a deed of trust state. Because if you're in a mortgage state, you already have a process in place that you can come in and use that with. But if you're in a deed of trust state, you can file a complaint or tort action against them, get the injunction, as well as go after them for damages based on the record and file that you have to show that they failed to validate, they never had standing, and they never had jurisdiction to foreclose in the first instance. So you're basically bringing a claim against them. You're going on the offense. But I don't know how you can use that in a trust situation when you defaulted them out under debtor-creditor. That's where I see a dichotomy there. Like Christian often advocates, it's all trust or it's all debtor-creditor.
I agree with that.
Although it is all trust under the guise of creditor-debtor. So in order for them...
I agree with that.
So from my perspective, in order for them to see and understand where you're coming from, you have to keep it in a law form that they're recognized, and at that time, you defaulted them out under their creditor-debtor codes. So to get the most bang for the buck here, you may have to go on creditor-debtor.
Then Harold,
Go ahead.
I'm sorry, I thought my response to that is I agree with you 100%. I'm glad you said that. That clarifies a ton of things for a lot of people who have their ACC that's already done. Now, the next step, which goes back to Christian, you and I discussed this twice, I think on last Tuesday and Wednesday's calls, is basically, even if you have your ACC, your administrative claim that's done, it's probably good to be proactive and create a special trust deposit, like almost like an interlocutory special trust deposit for this particular matter. We can't go chop the tree off, but let's chop a leaf or a vine off and go after that. And we can do that by creating a special trust deposit, sending it to them, and then putting them in a position where when they fail to return stuff and discharge and settle some type of intermediate presentment that they've given to you, a bill collector or otherwise. And you can do this in a mortgage case with some type of, if you're current or even not current, with the last presentment that you got, you can turn that into a special trust deposit, send it back to them through the Moving Titles platform, and now once that time has cured, maybe you gave them 20 days to respond to settle the account. They failed to do so. You give them another 3 days in kind of hybrid debtor-creditor. And again, once they're in default of that, you have made a special trust deposit with your special trust deposit instructions enclosed therein. Now you can bring a proactive claim, which is probably for most people going to be some type of temporary injunction, a TRO, and then you can allege all those other pieces in there, the breach of trust, conversion of funds, and all the other damages that you're incurring in the public based on a special trust deposit. So it's almost like this, you're running two parallel processes, but that special trust deposit is what's required to get that thing going. So Doug, and Doug, if you want to weigh in on this in a minute after we get some feedback from Harold or Christian, Doug and I were working on creating a special trust deposit out of an intermediate presentment that we could send to them, let them put on deposit, and then run a 20-day and a 3-day non-response process, and then open up a court case based on that. That's my feedback for that.
Mm-hmm. I don't see anything wrong with that so far.
Yeah, that's an interesting approach.
It's the technical details that I'm having that Doug and I are both kind of wrestling with, which was making a solid presentment and special trust deposit using what we know, but then tweaking it. And I know he gave his 2 cents on how to do that. But basically, we were going to take a lunch, and that was going to be the beneficiary signature or the acceptance of that. And then so we have multiple signatures on there, one with the acceptance of that, and then the and then essentially the authorized agent instructing the trustee to, rather the grantor instructing the trustee to hold this in special trust deposit until it has been, for specialized purposes, until it's been recalled back. So we're working on those two pieces, and again, we have some more work to do, Doug and I, and Pete too, if you want to participate, and then maybe tomorrow we can send it to Christian for basically the creation of, this intermediate presentment trust deposit that we can then take to court.
So if I'm hearing this correctly, it's almost a reverse of what they have done to us.
Yeah.
Because you're using the trust deposit in your favor, and you're going back at them under the guise of debtor-creditor with the trust.
Yeah. I've been looking at this too.
Go ahead, sort of, not Harold. If I may, that's not exactly true. We're just using the timing and the notice and due process involved in the debtor-creditor side. But all we're doing is we're taking a presentment, we're accepting it, we're with an allonge attached to it. We're going to send it back with instructions to make it a special trust deposit, and then we're going to give them a timeline. Otherwise, they have nothing to work under. So we'll give them 20 days to settle and close this matter, and then they won't respond. So we'll give them 3 days. We'll probably do that through a certificate and a non-response as well, because that's a record that we've created that they have it, they failed to respond to it, they failed to adjust the account, and then they failed to return it. And so now with that, then we can go into federal court, and we can open up a court case claiming all the things we just talked about from a trust standpoint, conversion, and otherwise, keeping our records private, of course, and then going into chambers once we have that clearly delineated as confidential information and trade secret.
Now, how would you be going into court? What would be your law form?
Christian, go ahead.
Yeah, I was saying that it could be simpler. Yeah, that way you keep it simple that way, and not confuse it under debtor-creditor. Treat it strictly as trust.
Christian?
Right, 100% is trust.
Yeah.
Yeah. Mm-hmm.
So what law form do you use in court?
What was that,
Harold? He asked about the law form in court to be used. Well, the law form is going to be trust law, but you have to come in on the public side, and you have to claim breach of trust, conversion of funds, and all those other good causes of action. Put a nice, healthy pleading in there as coming in as a plaintiff, and then when the court says, I don't see anything here that's related to what you're talking about, you have your UCC 1 and 3 and your transfer and your record that you built, bring that into the private. That's when you get your judgment. And if they're not a stop from coming at you in any way before they get that resolved, then I'd be surprised.
Hey, has anybody got the SNAP case, the details of it, other than what's available on the internet? Has anybody got the details of it?
You would always have to probably go to the court to get that record. Most Supreme Court docs are available. Because that went all the way up to the Supreme Court, correct?
Yeah, that was a Supreme Court decision, yeah. I'd be interested in seeing how the details, how the case progressed.
Right. Those records should be available.
Hey, Christian?
Yeah, Rhonda?
When JC was talking about there a second ago for settlement and closure, didn't I hear you say Saturday night that it should be closure and settlement?
Closure and settlement, yeah.
Because it can't be settled till it's closed?
Right, yeah. Gotta, close the box first after you put stuff in there to set off, and then before you're going to get a settlement.
And if you're merging the title, if you're going to fix their misconstruement that you're the trustee and merge the titles back to them as trustee for closure and settlement with the merged titles now, what would be the appropriate amount of time to give them for disbursement? Because you're going to be asking for disbursement now that the titles are merged, correct?
I would say, they're giving you like 10 days for an NOI, and they're giving you 20 days for an SOI together, so that's 30 days.
Let me take that back.
Through the court, probably 30 days. Everything runs on a 30-day cycle.
It wouldn't be a request for disbursement. It'd be an order for disbursement.
Yeah, it'd be an order, yeah. I would probably put an order disclaiming the fact that they're saying that I'm the trustee, and then reverse it back on them with the order for the settlement.
With the merger of the titles and the order for the closing settlement and disbursement.
Order for merger of the titles, and order for the discharge, and order for the set-off.
Now, in a situation like that, because you've talked before about an order for closure, an order to close the public side, and an order to close the private side, but on a situation like this, would you do the same thing? An order to close the public and an order
to close the public side, that's the order for discharge, and to close the private side, that's the order for the set-off.
So there'd be two orders
the same model. It would be the same as for whatever trust, all the same thing.
Actually, there'd be three
orders.
orders.
Whether it be the main master trust, want to terminate that straw man account, or court case, whatever. Same model. They both have public and private sides. Anybody else?
Hey, Christian?
Yeah, go ahead.
It's Chris in Florida. I was having another conference call today, and they came up with another idea that was kind of good when you're in foreclosure, and that is go to arbitration. Because they're not going to ever, respond back to anything you send in. So if you do through arbitration, the arbitrator rules a judgment in your favor, and thereby issues a judgment.
If you do that, let me interject there. If you do that, make sure the arbitration agreement that you sign does not foreclose you from going into court with an adverse decision. A lot of times those agreements, they try to make it final with the arbitrator without you having an opportunity to go to court and appeal. So if you do use that process, which is available, make sure you don't cut yourself off.
So what you're saying, make sure you have the ability to go in an appeal?
Make sure you have access to the court. A lot of those agreements that I've ran through over the years, they try to get you to waive your rights to court.
Okay. All right, cool.
And make that arbitration decision final. And I don't always agree with that.
Right. All right, thank you.
Okay.
So, JC, got anything else there? Another question?
Yeah, Christian? Just on again. Okay, on this order for closure and settlement, that's on the public because everything's backwards on the public. So on the private, would it be for settlement and closure on the private and closure and settlement on the public?
Well, I'm just going to put one order in for settlement, and the order on the public side, close and discharge, that would be an order for that, and an order for to close and set off on the private side.
Okay, on the private side, it'd still be closed first and then set off instead of... Because normally on...
The closure, closed account was in the blacks there. it's, let me pull it up here.
Yeah, but the black, that's in the public.
Right.
Because out here in the real world, we would usually think you settle something first and then you would close it. You'd settle everything, you'd settle up with somebody, and then your deal would be closed with them. So that's why I was just thinking, okay, over in the mirror image, it's closed first and then discharge. So maybe
I see what you mean.
In the white side, it would be set off first and then closed.
Has anybody looked up that in a pre-33 dictionary, see if that changes around? So this was under account.
What term was that again?
We're distinguishing between the private side being different terminology and it being reversed, say, than on the public side. Because we've been saying all the time we want to close and settle the account. We want to get a statement of account for closure and settlement. I did some research on that, and I found out that actually we're talking backwards, because it should be closed first before you can settle it. The definition of under account, under Black's 8, it says closed account. It says an account that no further credits or debits may be added to, but remain open for adjustment or set off. So it's like you got to close the account first and before you can settle it. But Rhonda was making up the distinction, well, maybe opposite in the private. It may be settlement and closure, where on the public it may be closure and settlement. But I think all these years, I didn't really question until I started reading the Black's Law, and I ran across it. Well, that just didn't make sense, because we've been taught all along under debtor-creditor, everybody I've always talked about or talked with always talked about you got to settle and close it. Always ask give me a statement of accounting for settlement and closure. And I came to the determination, I think, that's backwards. We're not saying it right. We should close the account first and before you're going to settle it. So that was just a little thing that I threw in there the other night that everybody would think was speaking backwards on that. But then Rhonda made up that distinction. Well, maybe it might be under the private side. Maybe that's the way they call it.
Well, because everything's backwards from the private, right?
Yeah, true.
Mirror image.
Then I really want to just put in enough information, maybe just to leave the Leroy open so I can just come in and straighten anything out and keep it under this principle. I think we tend to maybe complicate things up too much by putting in too many details, and then we start splitting things up and we start getting in deeper and deeper and deeper into it, and next thing you know, we've lost the focus and muddied the water with a lot of details that can be snag us, because we haven't left ourselves enough leeway and a door open to really express our intent and purpose. I noticed that in Gilbert's, it wants you to specifically state by the indenture what your intentions are, and then they come back and say, well, if it wasn't, then that gives us the right to construe it. But I like to think that, well, I still have the final say-so if I'm alive, because I can come back in and tell you what my intent and purpose was and straighten things out. That ability, I like to say, well, I can leave the door open and give myself a little more leeway. If I'm dead, it won't make any difference then.
I think that's interesting about the point you made up about maybe we get, keeping it simple, because I was reading on trust. This lady had wrote on trust, on the Constitution and all that, and she was talking about how when you get specific and start naming errors and stuff, you really limit the trust. The more you name things, the more you limit the trust. The more boundaries you put on it.
A more narrow path, yeah. So any comments on that?
Oh, Christian, did you get my email from yesterday?
No, I haven't looked. Well, I probably got the email, but I just haven't opened my email up for about at least a good week.
Okay. I sent you the stuff that I did in Ohio. That got the win in Ohio.
Oh yeah, right.
Yeah. Because in that one, I started out. I used about a 4-point approach, and the first was the trust. But I had backups just in case they didn't want to go there. They didn't answer a thing. And I told the guy right from the gate, I said, they're not going to answer this. They're going to write it out, so allow the court to dismiss it. And that's exactly how it played out. What happened is after the time the court issued an order for them to move, then they did it again. And after the second time it was up, I put in a motion to dismiss the entire action. On the 2nd of February, on February 10th, the court dismissed everything.
Are you going to come back at them with some kind of independent action or counterclaim and sue the pants on for damages and whatnot?
I don't know if I can get the guy to go that far. Because him and his wife is getting ready to go through a divorce, and it's a mess. So, being that it was done without prejudice, they may try to come back, but they can't based on the issues that were raised that were unopposed. So I told the guy to get certified copies of the order, and also get certified copies of the motions themselves. And they'll be waiting in case they try to sell a note to somebody else and they try to come back in later.
Mm-hmm. But how about that? What we were talking about once before, that the actual dishonor transfers with the note. Whoever has the note and is holding the note actually has the dishonor, goes right with the note.
That's correct. So that's why I wanted to get certified copies of the entire record. That way, whoever picks it up, here it is. The dishonor is here. You can't move. Because in that case, that started out.
Can't form a trust. And really, they're testifying as the real man, and they can't do that. So we should do a reversal on that and say, hey, point out the record, point out the record, point out the record, and the record is going to, nullify their what they're saying, their oral contract.
Well, first of all, they won't be able to bring it in at all because they have no record.
Right.
They have no record. And that's where you have to cut the attorney off at the pass, and which I do in almost all my motions. I make a section that deals with the attorney can't testify in the matter. So once you cut him off, you neuter the attorney, they have nothing. Because remember, all the trust docs that were created were by you.
Mm-hmm. I was trying to think of, the scenarios. How are they going to respond in court? And the only thing I could think of was, so they're just going to deny that it says that wasn't the intent of the plaintiff or whoever was the bank, say, to form a trust. How would people respond? How would they respond?
Go ahead.
I was trying to point out, how are we going to defend that? Because they're going to try to get you to traverse back into their side of the public debt side, into the debtor-creditor, and what you need to do is get them to argue about your record under trust.
Yeah, because I added, like in your expression of the trust, I added the element of the creation of the trust by and through the note and the mortgage on that specific day and time as an element to prove the trust. And what were the docs in question? So I added that in there. So, because I remember you had made mention of something, I said, wow, this is a good idea to put in right in your expression of the trust, that how the trust was created and by what documents. The trust was created through the mortgage and the note, in which you were the issuer and maker thereof. Now, how can they refute that?
So they didn't respond to nothing. They didn't respond to any of that stuff. No, nothing.
Nothing in the whole entire motion. Not one word. And I figured it was going to work out that way because they couldn't deny anything. They couldn't deny the trust, because once you express the trust through the note and the mortgage and also through the court case, how can they refute that? What record do they have to refute that? Like you said, he who claims trust...
You come in with a counterclaim, a filing, or just a straight answer?
No, I came in with a pre-answer motion to dismiss. Most of the cases I deal with don't even get an answer part. What's that again?
So it wasn't a counter...
No. Yeah, most of the cases that if I get to the case early, excuse me, something in my throat. If I get to the case early, within the proper time to respond, I rarely ever get to the answer stage. I knock them out right with the pre-answer motion to dismiss. Because once you hem them to the wall with standing and jurisdiction, because everything is presumed until you rebut the presumption. And in a lot of the states that I've worked in, it allows them to go into the court with a skeleton complaint with no verification. So, but however, once standing and jurisdiction is objected to, now the court has no choice but to look over to the plaintiff and says, prove it. And that's where they all get stuck.
Be ashamed not to come back in with the trust violations and stuff for the note on there.
Well, actually, that's an area that could be explored.
Harold, this is JC. I have a comment for you. Breach of trust, conversion, and all the other stuff.
Yeah, that could act, because that also goes to their standing also. Yes, sir, JC.
I love you're one of the few people who seems to have a good mastery of court procedure. And like you said, that's half of what we get hung up on. One of the things that we brought out in the last call was you don't need to come in as a real man, real party in interest, because all you need to do is the rule of signatures.
That's
correct. That's all you need to do. Nothing more. Other than that, it just becomes non-colorable. So if there are people on the call right now, I'd like to connect with you maybe tomorrow and talk about some court procedural stuff. I don't want to have to give out your Skype name or my numbers either. But does someone else on this call have a way to get a hold of Harold?
Yes, I do.
Yeah. Okay. Well, if we can
I appreciate that, because I know there have been times I gave out my numbers before and I got inundated.
Right, exactly. Well, maybe, Christian, if I could email you tomorrow and you could at least just put us in contact with each other so we can talk about some of these procedural items, that would be great.
Okay, sure.
I'll email you before the call ends, if that's possible.
or if you're on Skype, I'll Skype you. I'm not on Skype now, but I gotta jump on Skype, so. Okay, great.
Could I ask a question?
Sure, go ahead. What's your name?
This is Lenora. I'm in Minneapolis.
Hi.
Hi. I have a question that maybe I could email somebody about and they could give me an answer. It's about, I'd like to, prove a trust for the mortgage, and I know you've been going over, I've been listening to all of the things, but this person, I'm in the will, and this person's in the hospital right now and may not make it. I'd like to know, is there something I can do to add to the will? We have a legal will, so that I may be able to still do this. If not, I won't be able to do it. So what do you think?
Are they coherent?
He's on a breathing machine.
But is he coherent?
No, he's sedated. But they're going to try to take him off of it tomorrow.
That might not work. He has to be coherent. Okay. He has to be fully coherent, and the doctor has to clear him that the medication does not affect his judgment.
Okay.
Otherwise, anything he signs in that state, that can be objected to by anywhere, and the courts will knock it down.
I understand. Oh, what's that?
Verizon Wireless. The wireless customer you called is not available at this time. Please try your call again later. Announcement 1, switch 4, 8-2.
Okay, are you still hearing me?
Wireless. The wireless customer you called is not available.
I don't know what that is.
Call again later. Announcement 1, switch 4.
Okay, so if the doctor did give him the thing where it says he's coherent, what would we add to it?
Well, if he's coherent and can understand what he's reading and what he's agreeing to, and you get the doctor to sign off with that, then it would be legal.
What would I have him put in there then?
What you mean?
Oh, so that I have power of attorney, so that I could go in and do all of the UCC documents. What would I have him add to the will so that I could do this while he's in the hospital?
Oh, no. I won't be able to advise you on that. You probably would ask an attorney with regards to that, because I don't know a whole lot about wills. But I do know about wills that have been knocked out by signings in the hospital or on deathbed. And a lot of them got knocked out. So that's why I was just wondering.
Well, I guess that what I'm asking is, I'm the one that's going to have to do all of the UCC filings and everything. And I was wondering, since I'm not the one that signed the mortgage, that's probably not going to work. Do you think that's right?
What kind of UCC filing are you talking about?
Well, to prove the trust on the mortgage.
Well, the one who signs the notes, that's the grantor on the trust.
Exactly. So he was. Sorry.
I was going to say, but as a POA, you still may be able to do the notice filing, because all you're doing is a notice filing on the UCC-1.
Well, then I guess I don't have to add anything to the will then.
Let me ask this. What is the purpose we're trying to achieve here?
I want to prove the trust on the mortgage and then merge the titles so that there's no mortgage to pay.
Okay, so the grantor is in the hospital, and he's on his deathbed right now, and he may die or he may come through, one of the two.
Exactly. Yes, that's true.
So you have power of attorney, trying to think whether or not you would need. Let's see. Well, who's going to be the grant? Who's going to be the beneficiary? I mean,
Me. I'm the beneficiary on the will.
okay. So at this point, I think the grantor is really, the living man grantor is like, it doesn't really matter because you have documentation already set up that he was the grantor in writing. And if you're the beneficiary, you're the one that's going to be making the claim.
Excellent.
So I don't think you have to have a problem here if that if that grantor would die. So.
Oh, thank you
You're
so
the
much.
beneficiary. You're the one.
Excellent. Okay, that's just all I wanted to know. I just thought that there would be a big problem since he wouldn't be able to make the filings.
No, you as the beneficiary could also make the filings because you're just creating notices of a present transfer that happened years prior. Now, that's a fact, but you need to establish the facts, and that's what the notices are, the UCC filing. You could file as beneficiary the filings.
I wouldn't even have to sign his name to it. I could do it myself.
You could do it yourself.
Excellent. Okay, thank you. I asked someone to ask this question for me tonight because I thought I would be at the hospital, but he's not even off the machine, so I was able to call in, and I'm listening to all this stuff, and thank you so much, and I want to join the group. I'm waiting for an invitation for the application.
Well, there's really no invitation to come in. It's just, get under somebody who is under the call if you don't want to be one of the parties that wants to be a teacher, so to speak. It's on down through. Get into somebody who is.
Okay.
If you're on a call, it's just a trust ambassadors group. It's just I have my 12, and then those 12 will have 12 under them, and then somebody you just fall on down line.
Okay. Thank you.
It's just the requirements is just to pass the knowledge on to somebody else. Pay it forward.
Okay. I think I'll be okay when you read from the book, it's like listening to a different language. And then sometimes it gets in and you didn't hear. It's very difficult to understand this language, and then sometimes it's just like normal. It starts to make sense. Like you're understanding this different language. It's very odd.
Well, we have to learn how to speak French. It's a different language, like.
I appreciate it when people ask questions because it's very hard to ask questions being so almost illiterate and not knowing how to even ask a question sometimes. So when people ask questions, that's really great. I love it when Rhonda gets on and talks. So I'm going to mute out now, so thank you.
Well, people have to realize there are no stupid questions. The stupid question is the one you didn't ask. So I wouldn't be bashful about asking questions.
It's very hard for me to ask questions. How do I mute out?
Press *6.
Hi.
Okay, anybody else?
Yeah, Christian.
Yeah, Rhonda.
Since there's no stupid questions, here's one. Here's one for you. Have you heard of this Restore America plan?
Yeah, I have.
Do you have an opinion on it?
It's a debtor-creditor plan, far as I can see. I don't think it's going to accomplish what it's meant to do, because it's not really coming at it under trust. The way I'm looking at it is the republic is held in trust, and the only way to get it out of trust is to, merge the titles, terminate the trust.
My
you terminate the goes back.
Not only that, I think a key element that's also missing from their plan is the to bring back lawful money. Because as long as we're using fiat, you don't have law. You can't be de jure.
Right. Yeah.
And that's a missing element from their plan. You've got to have lawful money in order to have true equity, and you have to have lawful money to have law.
Yeah, you have to have true money for even the common law.
That's correct.
True money for the republic. Yeah.
That's correct. So that's a huge issue that's not being addressed. So trying to invalidate what they're doing without the proper law form and money to back it up, lawful money is not going to work. And secondly, as Christian just stated, they're not coming from out. They're not merging the title so they can come out.
Well, it's just a little.
It's a good. Go ahead, Rhonda.
It's just a little suspicious to me because, well, first off, why reinvent the wheel? I mean, if you got the founding documents that are pretty much perfect, a perpetual trust, that's forever. I mean, supposedly the people that wrote this Restore America plan are the same people, basically, from the government that gave us the 14th Amendment. What it seems like to me is maybe people are starting to peel back the onion too much and find that trust, and it's just another way to trick people out of their inheritance.
I don't know neither.
I don't. Go ahead, Harold.
I was going to say some of the characters that are involved I have issues with, based on some of their previous actions that actually got people into trouble and into jail. So you got to be very careful who you follow. Like you say, it could be some sort of trick.
Well, it's just that we've all found out how important our unrestricted signature is. And, maybe they're figuring out, okay, people are figuring out they don't want to be a 14th Amendment, we'll give them another section they can sign on to. But I don't know,
It's the same thing with the people going into DTC, it's like the same situation there. I've got the same kind of problems about that up there. Same thing.
Yeah.
It's nothing more than another debtor-creditor rabbit hole ploy that I would think is, recognized as be, but apparently not. I don't know.
And what that makes that even worse is you essentially have to sell your soul to get in.
Right.
Because once you get in, you're so restricted in what you can do that it makes it hard for you to be a follower of Christ.
Right.
So I shied away.
Well, I think the path is so ingrained, such an habitual path. We spend so much time on it, and it's so deep that we continually go back to it like a dog to its vomit. And we're really not willing to look at some other methodology that may be even more promising. Yet we go right back to the same stinking path without using our brains and thinking, hey, this makes so much better sense under trust as far as I can see. I mean, it dovetailed things that I had trouble jiving with. things that didn't come together. Trust brings it together. I decided, came to a point that I'm going to say that, hey, I'm checking this debtor creditor stuff. I'm pursuing trust all the way from here on in.
Well, and here's another thing. Black Operations is supposed to be, being involved in this, and they wrote it. These people up in the government wrote it, and it's supposed to be confidential. So confidential that the people signing it can't read it. But it's supposed to be confidential under the guise that, well, we don't want, the enemy to know when we're going to attack, sort of thing. Well, look, if you're out talking about it on the radio, it ain't too confidential. I mean, if they know, they know it doesn't make sense.
There's a lot going on. We're living in perilous times right now. There's a shaking up going on, and there's going to be quite a few changes coming up, I'd say, within the next few years. And a lot of people are going to be devastated, unprepared, mentally and spiritually. And it's starting to happen already. Look at some of these bank execs. Some of them are starting to commit suicide already. And it really ain't bad yet. Look at the guy from Fannie Mae. What was it, last Wednesday? Committed suicide. Because some of these bad things that they have done are starting to come to light. You can't keep it hidden forever. And we're living in a time when knowledge is increasing abundantly. Just look what happened within the last 3 to 4 years, and think about what you knew prior to that, in your prior life, prior to those 3 to 4 years. It's amazing how the knowledge has increased. So now we're seeing all of these different vehicles coming up. You have to be careful what's real and what's not. There's a battle going on for the minds of men and women. The enemy works through the mind, through the spirit. It's a very serious thing going on.
Harold, I appreciate that. I'm not so convinced that everything we read and see is factually accurate, and until you see reports otherwise, there's no reason to believe those deaths are suicide either. I mean, there's just no way to know what lies behind the doors and the curtains that we can't see, that we don't have a window into. So it's very difficult to say.
This is true.
Christian, I have a comment for us about at least our process. And it goes to the SOI, the Statement of Interest. It seems like that might be a bit of a misnomer. It's more of a proof of interest.
Correct. Yeah, but
a statement implies something succinct, when in fact it's an evidentiary package we're putting forth. And I think some of the people in our group were confused about this. So I thought, look at this as it's your package of interest or your proof of interest. And so I wanted to see if maybe we should talk about that.
Well, the statement of interest is really out of Rule C of Admiralty, where notice of interest was the 10 days and then the SOI was the 20 days under Rule C. But really it boils down to, just like what you said, if they would maybe think of that as being the material fact. The material fact is what you need to make the proof. It is the proof. To prove the claim or the notice, the NOI, you need the SOI, which is the material fact, or the record of the material fact. So maybe if they look at it that way, the SOI is nothing more than a material fact. You've got to have some kind of a record.
Right. It is your record.
Yeah, the record. The material fact record. And that's what you need to prove the case.
That's why I started in the mortgage cases. I started introducing it right in the expression from the outset, because that's the basis of the whole alleged action. Is on those documents which the plaintiff introduced first.
Did you use that Nevada case? Anything in there from that one? Where it says that the
I know
grantor was the...
No, I need to build that in. Because my documents sort of grow with knowledge.
Has anybody done any studies on that and try to comport that to their own state? Well, I think it was Nevada Revised Code Statutes, what was it, 120... what was the number? I forgot. 107.020, I think it was. Anybody check that out, see if they could find that in their own state?
No, I didn't get a chance to check that out. Sometimes what I do also, to have the benefit under due process and equal protection, I use the full faith and credit clause, or statutes around the country to be used whatever state that I'm working in. Never had too many objections. And when I do use it, it's basically for illustration and persuasive purposes, not as the primary authority.
Oh, let's. Anybody have anything else to comment on trust? Did anybody? I think last week we talked about it at the end there about the little homework assignment. Did anybody get any farther with that on the little statement to, how to express the trust without using trust terms?
No, I didn't catch that. Or was I available? Because I know I was away for the weekend. So I might have missed you last Monday.
Well, Christian, Doug, and I spent some time working on that introductory letter along with the allonge. So we made some path down there, and Pete made some good comments. I haven't had a chance to incorporate your comments, Pete, on that, but it's a over a half-page document, but there's also instructions, segregation language, but it gets away from most of the trust stuff.
Mm-hmm.
So when you pop on Skype later, I'm sorry, when you're on Skype later and you send Harold's info over, I'll script that to you for download. It's not complete yet, but it's a working copy.
Has anybody ever looked at some of the bank stuff that they use, that they send out? Because the banks are really operating under trust, and they're sending out all these invitations and things for, they're talking about relationship and whatever else in there. Has anybody checked anything out there from the banks? That's kind of a good place to look.
Oh, Christian, now that you mentioned the bank, remember that project you were working on a while ago about redoing the indenture for the bank account?
Mm-hmm.
How did you make out with that?
That's what I was...
Was that again?
That's just what I was looking up right now. Yeah.
Oh, okay. So there's two things we talked about.
Thing for the bank here was talking about the important information for bank deposit accounts. So I looked up the definition of information, which is nothing more than a notice or a formal charge, and bank deposit is really talking about a trust account. it says, under the deposit agreement section, it says, when you open your account, you received a deposit agreement and fee schedule and agreed that your account would be governed by the terms of these documents, as we may amend them from time to time. These documents are part of the contract for your deposit account and govern all transactions related to your account, including all deposits and withdrawals. Copies of both the deposit agreement and the fee schedule, which contain the current version of the terms and conditions of your account relationship, may be obtained at our banking center. So the relationship.
That's trust.
Yeah, trust.
That's trust.
They say you opened your account and you received. It's all yours.
It's all you.
So why are you allowing them to dictate the terms?
Yeah, because
fee schedule and agreed that your account would be governed by these terms in the documents, as we may amend them from time to time.
Now, what gave them to a
So
party?
might use some of that wording in there, against them. Geared towards trust, and then send them a copy.
Yeah, but what I've been hearing, some people who have been challenging some things with regards to the trust, and in some other areas also, rather than comply or capitulate, they just close out the account. There you go.
Okay, there's where I come back with the greater power. The Court of Equity to compel them not to breach the trust under 4-103 under the UCC.
What was that again?
The variant.
Oh, the one that we went over.
4-10.
Yeah.
Yeah, 4-103.
Yeah,
Variation by.
We went over that Saturday, right?
Uh-huh.
Yeah.
Because I really think that's where we have the greater power to prevent them from breaching the trust. Which comes back down to really antitrust, because they got all the attorneys, all the power, and if we don't sign the contract, they're going to pull the offer off the table. Well, I think that's unconscionable. We got an unfair business practice here.
So
You're trying to get me to debtor-credit relationship when you want my signature and I'm expressing it to be a trust and trying to make a special deposit with you.
okay, so within the docs that would be created, you would have to have those notices in there, so in the event they even think about withdrawing, they will be put on notice ahead of time that they would be in violation of antitrust, etc.
Right, and it's right at the close of the official comments under that section 4-103. It said, before damage rules of the section become operative, liability of the bank and some loss to the customer or the owner must be established. Well, liability of the bank, claim trust. Claim that there was a trust liability there. And due to their pulling out of this, now we've got a loss.
Yeah.
Establish these facts. They prove the claim on that first. Now you got damages to come in with. I think that would make these banks start thinking twice before they start doing this.
Well, Christian, what about the people
forward? Yeah, go ahead, JC.
About the people, the tens of thousands of bank levies that have gone out there, that they were damaged in fact because their funds plus $100 were levied out of their accounts and transferred to a third party.
Yeah. Right, there's a loss.
You can find a loss anywhere.
And the irony is they almost switch your role where you're actually supposed to be the beneficiary of that trust, they almost act as if they're the beneficiary.
Well, it's like when you shine the light on the darkness runs away. But trouble is, hey, you can't get away with that because, now you know and understand what's going on. And really we should be taking and getting them for compelling them not to breach the trust because they're breaching the trust.
Yeah. And remember the other one we were talking about a while ago, this is almost 3 or 4 months ago maybe. Remember the writer that we were talking about developing for to put into the record before that 72-hour period is over? That's another one I'd like to get back onto. I really just don't have the time. But that's a good one. That way for people in the future to have an opportunity to express the trust within that 72-hour period.
Right.
They, perhaps can close out the case without even having to make a payment.
But I think we need to come at these people more. We're so glad to get out of the case and get a breather that we just give up. I think we should go on. Got to. If you don't punish the wayward child, he's going to go out there and do it again.
Yeah. And they're definitely wayward children.
That was actually the theory behind Doug and I working on the intermediate presentment and the allonge attached there too. Thought was that we can take any presentment, and even especially for the people that are right now, they don't have any issues. They're just cruising along, knowing that there's fraud in the mortgage, but they're not even behind in their payments. So they take whatever latest statement that they have, turn that into a special trust deposit, give them instructions properly with the allonge attached there too. And you know what? If they don't respond, or if they don't settle and close the account like they're supposed to, like a good trustee, boom, you're right into federal court as a plaintiff, and now you're taking them to task. And if they don't wake up, then they're going to be in real trouble. I think that is a way single-handedly we could have tens of thousands of people getting remedy, and without even being contemplating that they're in a court case.
Uh-huh.
The last part, what I meant by that was, I misspoke. What I meant was they're just happy paying their $1,200 a month for the mortgage. They're not behind. And then they can take the banks to task, and we can show them how to do that. They're not in default. The bank's not suing them. They're coming in as a petitioner or plaintiff.
Yeah. Actually, we'll be in a better position if you're coming in on the offense in that particular situation. Because they can
because you'll... I'm sorry, go ahead.
Prove up their claim.
Yeah, and you stay as a petitioner plaintiff. You're always on the offensive. They can come in and counterclaim something, which they probably will. They'll try and get rid of the claim, and they'll come back and allege something else.
How can they effectively counterclaim when they cannot introduce an adequate record to refute your trust?
There you go.
They can't do it.
So I think taking any intermediate presentment that we get from, I think that should be in part until we get the root of the tree chopped off. I think any presentment that we get from a debt collector, from the IRS, to mortgage company, to a law firm, all those I consider intermediate presentments, and we can do the same process for them. And then It costs you $400 to open up a federal district court case and file an action. After you run your administrative process, you are sitting in the driver's seat, as far as I'm concerned. And for a lot of people, that might be a pretty good solution for them.
As long as you get the end game down pat, because that's where most people fall down with that administrative process. They can't bring it in on the public side correctly, and then they wonder why, when they bring it before the judge acts like it's not even there.
Well, that's a great part about this process. It goes back to SNAP. We're not going to sue them under breach of contract, even though we have a private administrative agreement between the parties. We're going to take them to task on the trust. They're going to be the breach of fiduciary, conversion of funds, all those other things, which is why, it just goes back to all that, and it leaves them no wiggle room. Yeah, unclean hands along with that because they failed to respond to you. So there's a whole range of things that are in there. I never respond to it. And along with that, you could start to claim fraud and damages and treble damages that go along with that. And then you settle out of court. All you want is free title and maybe 1 times the sum of the note, because you're not greedy. They can have the other 2 or 3 or 10.
Greedy, I'd go after the treble damages myself.
Well, that's where your settlement, negotiation, arbitration skills come in, and for a guy who's getting a free title and maybe something on the top, you may walk away and think he just fell into a ticket flop. Who knows? You're right. There's a jugular, and some people are capable of that.
I know of a guy out of Ohio. Now, his exact process, what is he doing? I don't know. Whether it's in debtor, creditor, or on trust, because he won't reveal. But what his experience taught me was the value of the note to them, to the bank. And I subsequently tied that together with what a banker had brought to our attention. When they move these notes around, these securitized copies of notes, they're actually actively participating in passing around counterfeit securities when they do this. So say, for instance, you close out with a bank. They immediately, actually before the deal is closed, they basically already have it scheduled to go to another entity. But that may happen anywhere from 10 to 50 times afterwards. And it winds up on the bank's assets. So that might happen about, anywhere from 20 to 50 times. Now, when you go in and request that note back, that is causing monumental problems. It's just like if you go through the IRS and have them to go in to close out escrow. That causes a lot of problems because wherever that note had landed out, because they got QSITs attached, it has to come off all of those books. So this guy, Gary, understanding some of these principles, he puts in his process when he gets a callback, it's from the CFO or the CEO, nobody lower. They're offering to cut a deal. And the deal that I think it was from his first experience, and he basically uses it for the rest of them now. When they first wanted to cut a deal, they offered to release the lien, market satisfied, clean up the credit of his client, and bring the score up, and also give the face value of the note in their so-called money. In return, to leave the note in place. So that's when it hit me. Wow, that note does have value to them. And then when I learned from this other banker as to why, so now they would have to unwind every time, everywhere that copy of the note landed, they have to unwind it. And it's coming off all of those books. So it's cheaper for them to leave it in place, pay the face value of the note, and give whatever property and everything, they just release everything. It's far cheaper to go that route, to unwind, and then also may have to pay all the derivatives that came off of that account. Because if you ask back for the note, the escrow, all derivatives, and plus your equity, it's in their best interest to let you keep the house.
Harold, that's beautiful, and I love that, because you're right, it could be monumental, it could cost a fortune, and you know what, there's a parallel, there's an analogy to that, and I can't validate this, but I have heard, and this is maybe why so many people in the community are not getting the OID relief that they should be getting, or they are getting hammered by the IRS because they filed OIDs and they've gotten a return, and now they're looking at some kind of criminal prosecution. And what I'm talking to an associate of mine, his allegation is that his first question was, was that person have an SFR, substitute for return, filed on their behalf by the IRS? If they had, then his allegation was that somebody internally had filed the SFR and already claimed those as abandoned funds. So those funds are gone. Somebody walked off with those several $100,000 years ago with the SFR, and whether it's a rogue agent, whether it's a internal group that does that, and that's just how they're funding their own sources and operations. But that was the allegation. So now, when you go back and either you do your OID, you go back and claim some funds, and you're trying to settle out your account, well, now you have this imbalance that they can't fix because somebody has already claimed those funds, and they've already absconded with them years ago, and the account is imbalanced. And to cover their tracks, they're just going to try and either warehouse you or let it brush under the rug somehow. So the analogy of going back and making some kind of a settlement offer or to settle out the account and not bring criminal prosecution or not bring on charges or to engage in that conversation at the CEO, CFO type of level might start to make sense to the extent that there's any merit to that speak at all. It might just be the case.
Possible. I think the major problem with people going in on the OIDs is that they're actually going in as trustees demanding something that's only available for beneficiaries. There's a lady in Ohio, this is another person out of Ohio, and she's familiar with trust law, and she actually processes these things, and she makes sure that she establishes the trust, everything with the IRS, and they go in as beneficiaries. She has none of her OIDs been reversed that I know of, and I've seen the checks. So I believe that's another problem also. A lot of people are going in there the wrong way. They're going in because based on their 1040, they basically admitted that they're trustees. Right. Trustees have no right to demand that money.
Gilbert states that the trustee is the one who has to defend the trust, but the beneficiary has to make the claim through him for something else.
There you go.
And how is that lady in Ohio establishing their beneficiary status?
She does it by declaration. Give them the appropriate time to respond. They don't respond, then she files the process with that documentation with it. The last I heard, as a matter of fact, I heard from her today. She had some other issues going on, but nothing with IRS. She's been doing.
I'd like to see how they're signing that 1040, because that 1040 again, unless you're expressing your through the rule of signature or something other than just a clean signature, and generally anything other than a clean signature will get it kicked out as a frivolous filing. I'd like to see how they're doing that entire process. See, that's the technical details that we all hear about, but nobody quite gets their fingers on.
I know for a fact, based
Say that again, Jason. Is the what about the signature again?
Well, when you just put your clean signature on at 1040, you're going to come in as a trustee. They're going to construe you as a trustee. And if you do anything other than a clean signature, you come in as by grant or by beneficiary or authorized agent or something else in there, and you try and change that acknowledgement, they're going to reject that as a frivolous filing.
So they're giving you frivolous filings because of anything other than a clean signature, you're saying, yeah?
Correct.
Well, let me enter my experience. I did a tax return for someone, and they went in as I believe it was authorized agent, and it did get kicked back the first time. Then we sent it back with explanation, and it was accepted.
Yeah, I was just going to say that really that would almost be proof that you're coming in as a trustee. If they're going to give you frivolous filings all the time, if you come in with other than as filing as a trustee, then what you just said, Harold, that just kind of points out the same thing again.
Yeah, that's personal experience. They did kick it back the first time, like you said, JC. But I went back at them with the same, because they sent everything back, all the originals. They sent it all back. And then I went back at them, sent those originals back with explanation, and that was the end of the story. They did not.
What was that explanation? Can you give a thumbnail of what that was?
Well, they rejected the signature, saying that wasn't her signature, and There was a small explanation. It wasn't large. I didn't go into the trust stuff that deep, but we did substantiate the fact that as an agent of the principal, that is her signature as the agent. And it didn't come back. So she's not the principal. He was only the agent of the principal. The principal is a trust.
To me, that just is one more indication that it all boils down to the operator. You can walk in with your international driver's license at the bank and sit down with somebody and open up an account one day, and the other day you get max grief over it because they don't understand it, they don't have a valid ID, they need your social security number, and you get this big runaround. I think, it all boils down to the operator and the day that's going through, and that person may have looked at it and said, well, this is adequate or enough, or just push it through. Who knows why? But that's I liken it to Christian's concept. That in the debtor creditor land, you get 10-15% remedy. Things sneak through, things get payments, things are not harassed occasionally, but it's spotty. You never know what you're going to get.
That's true. And what was I getting ready to say? I forgot the thought. Okay, go ahead.
When you read the frivolous filing documents that the IRS has posted on their manuals and website, they have a laundry list of things, and that is one of them. Is that you just anything other than a clean signature essentially will get you a frivolous filing. It'll get it rejected. I mean, they have 500 things that will cause that to be sent to the frivolous filing department, and then you're in that holding tank for 2 years.
But how can they determine what is your signature?
Good question.
That's not their position. How is a corporation going to tell you what is your signature? What is your mark? And what is your status? That's up to you to declare that, not them.
I'll give you a real-world example. I went back and expressed the trust and re-signed the documents, the signature cards on an existing bank account, and signed it by grantor, real name, and I sent it in, and I gave it back to the vice president, and she made a copy of it, sent it off to corporate, sent it off to compliance, and I get a call 3 days later saying, well, they can't accept it because they can't accept the signature. And I said, well, that's my mark, my signature. It's what's on my driver's license. I can send it to you as a copy if you'd like, but that's my legal signature. And I didn't hear back from them, and I haven't followed up to check and see if they threw that away and just kept the old signature card. I should probably do that. I have a follow-up, but, again, it goes back to that was my answer. That's my legal signature. How can you refute that?
There you go. Yeah, but there are some people, either they're being trained to not accept it or they actually know what's going on, and they want to keep you in that realm. And commerce, as Christian stated over and over again, you never want to give an unrestricted signature in commerce. Because what happens is you become the accommodating party, the surety. That's why they want to come and snatch the body or snatch the assets of the body. That little tidbit, the rule of signature, so powerful. So powerful. Because if you get into court and you say, well, the judge, what is it? How is the signature signed on that doc? Am I the principal or am I the agent? By the time he answers that question, the case is over. You can't come after me. You got to go after the principal. If I didn't commit a crime, you can't come after the agent. What is that? UCC 3402 or 403 in that area? And then there's another reason why, it makes it hard for them to monetize.
Well, it's a little after midnight, so why don't we call it an early night, so. Any closing questions? Last thing?
Can you just check your Skype before you crawl into bed, Christian, please?
Okay, all right.
Thanks.
Oh, you say he crawl into bed?
Or wherever he lays his head.
All right, guys, well, see you tomorrow night at 10 o'clock, so.
Lord willing, if the creek don't rise.